appeals in the matter of Mohammed and others, Daji and others.
Mr. Holland.
May it please my lords, I appear with Mr. Ted Loveday for the appellants, who were referred to in the judgment as the LBMW defendants.
That's derived from the former solicitors.
The Bolton Monier Williams, that's right. Technically D2, D10, D13 and D16 to 24. If I may, I refer to them as the defendants or the appellants collectively. My learned friend Mr. Sefton KC with Mr. Fowles is lucky enough to appear for all of the claimants or the respondents, and I will refer to them as either the claimants or the respondents. If I may. The appeal assisted for a day and a half. I had a brief discussion with my friend Mr. Sefton, and I thought, again, subject to anything which my lords have to say, that I would be on my feet until somewhere between 2:30 and 3 o'clock this afternoon, and that would leave my learned friend a good hour this afternoon and 2 hours tomorrow, with perhaps half an hour for me to respond if that's appropriate. I would hope, although he gets less time, that by the time he gets to speak, you will be more familiar, if you're not already, with the relevant materials.
That sounds fine if Mr. Sefton is content.
My lords, at paragraph 23 of the judgment, the judge sets out the list of agreed issues. That's core bundle 10127. And the essence of this, and what the essence of the relevant finding, is on issue 1. And he decides issues 2, 3. Well, he decides issue 2 in the light of his decision on issue 1, and this appeal attacks his decision on issue 1. We accept that it's a finding of fact, but we attack it for 3 interrelated reasons. First of all, we say that the judge was wrong to accept the evidence of the first claimant, and can I call him C1, Mr. Mohammed? He was the key witness for the claimants. Wrong to accept his evidence as to what transpired at the meeting in November 1994, and in particular, his evidence that at that meeting it was decided that the money would be donated to a new trust separate from the existing Dewsbury Trust. And again, if I may, I'll use the judge's shorthand of Dewsbury Trust, London Trust. And that is, I accept, a full frontal attack on the judge's findings in that regard. Secondly, I say, in any event, the judge was wrong. Well, the findings of fact that he made and that he relied upon in particular don't support the finding that he made. At paragraph 144 of the judgment, and that's the key finding, he finds that the donors intended to give or lend the money to a new trust, the London Trust. But we say that if you look at the judgment, if you look at what he relied upon, it doesn't show that. We accept, and we say he's mischaracterized the issue as well. We accept that the donors intended the money to go to purchase the London site, and we accepted that the donors would have intended that the London site would be used by the local community, as Christian Street was. But the key issue is not whether that was the case, and we say that was always accepted. The key issue is whether the donors intended to go one step further and say that, in fact, we're not giving to Dewsbury at all, we are giving to a wholly new trust with C1, C2 and D14 as the trustees. And we say the judge's findings don't come up to that. And thirdly, we say that the judge's treatment of the receipts and the way he sidelined them was illegitimate. He shouldn't have done that. And if that's right, then those were the key contemporaneous documents which evidence the objective intention of the donors. Now, 1 and 3 are standalone, can be viewed as standalone, but all three are cumulative, we say. And for that reason, we say if we're right on one or more of those, we say the judge's conclusions cannot stand. The upshot of that, we say, is not that you need a retrial of this, but that this court should determine that the donors gave to the Dewsbury Trust. Why? Because the judge was faced with a choice. And again, I'll take you to this when I'm dealing with point number 2. The judge was faced with a choice by the parties. It was either London or Dewsbury. If, as we say, the judge's conclusions, findings in relation to the London Trust are unsustainable, the only other option is the Dewsbury Trust. And that's the end of it. This court has the power under CPR 5220 to make that ruling. It's inevitable, we say, that is the proper ruling. The case will have to go back to the judge, perhaps for a ruling on the CPRE. I never know how to pronounce that. Is it CPRE or CIPRE point?
I think it's CPRE. That's how I've always understood it.
I'm grateful. I'll take that. CPRE point, but there is no retrial needed on this particular issue. Briefly on the law, there are 3 aspects which I suppose of the law are relevant. The first is the relevant test for the intention of the donors. That is, what test was the judge applying? The second is the relevant learning on the caution to be exercised by a trial judge in his or her treatment of oral evidence. And the third area is the applicable test for an appellate court in overturning a finding of fact by the judge. Now, I don't believe that there is any real difference, in fact, no difference at all between the parties on those issues. So, as I said, this is not a case where you're going to delve into the law to a great degree. But I'll address those briefly, if I may. Not issue 1, that is the relevant test of intention. I'll deal with that shortly, because I'm going to deal with the issues that I outlined in reverse order. I'm going to start with the receipts. I'm then going to go to the findings of fact, and then I'm going to deal with attacking the judge's finding of fact in respect to the November 1994 meeting. Issue 2, I'm going to deal with by making the point on the last of those points, that is the November 1994 meeting. I'll deal with that briefly. On issue 3, I'll deal with that now, if I may. And that's the relevant test for this court in interfering with the judge's findings of fact. We accept, as we do in our skeleton and in our grounds, that the judge's ruling in paragraph 144 as to the applicable trust, the relevant trust, that is the donor's intention, was a ruling of fact. My lords, you will see in both parties' skeleton arguments reference to various authorities which will be well known to this court, many of them judgments of Lord Justice Lewison. In particular, Faye, I think that's how you pronounce it. I had a pot of their yoghurt in my fridge. They say on it it's Faye, F-A-Y-E-Y, so that's Faye, Volpe and McCarthy. And my lords, I don't propose to take you to those, but I accept there are 4 perhaps relevant conclusions. First of all, I accept there's a heavy burden on the party challenging a finding of fact made by a judge after hearing oral evidence. Secondly, Lord Justice Lewison has used the phrase, one has to show that the judge's decision was rationally insupportable. That's perhaps the highest it gets put, but that perhaps is an illustration of the heavy burden that falls on the appellant.
Well, indeed, that fits in with the way you express it in the grounds of appeal, which is irrational and or perverse.
Yes, that's right. I accept I have to show that, and I don't shirk that challenge. I say you can. But yes, whether it's equivalent to the judicial review standard, it doesn't matter, I suppose. But it's there has to be, you have to undermine the judge's conclusions and show that they were unsupportable. Thirdly, a judge is not to be criticised for failing to deal specifically with each and every piece of evidence in his or her judgment. And fourthly, the judge is deemed to have regarded what Lord Justice Lewison refers to as the whole sea of evidence presented to him. And indeed, this judge said he had done that specifically. Can I ever ask you to look at one particular case, which is the Datek case, which is in usually a bundle of authorities, and that's Divider 2. And can I ask you to look particularly at paragraph 46 of that? I don't know whether I can invite you to read it to yourself. You're probably familiar with it. Or if you're not familiar with that, you're certainly familiar, I suspect, with the, I don't know how to pronounce it, the Generali versus Arab Insurance case, which it quotes. But can I ask you to read that to yourselves, my lords?
Yes.
I'm grateful. I'm grateful. I just draw two further points from that. First of all, it's necessary for the appeal court to make up its mind, very obviously. It's once permission has been granted, it's not simply throw up its hands in horror and say it's a question of fact, we're not going to bother. I'm not saying that this court would ever dream of doing that, but that's the point. You have to consider whether the judge was right or wrong, and on the appellate sense you have to make your own minds up. And secondly, the appellate court's approach depends both on the nature of the finding challenged and on the nature of the evidence which the judge heard. And can I make one further point here? We are accused, entirely understandably, because if I was in a friend's position, that's exactly what I'd accuse him of doing, of inviting you to island hop in the rather graphic phrase used by Lord Justice Lewison. And I'll deal with that. I say we're not. But the island hopping point, and the point that the judge is deemed to look at the sea of evidence and not necessarily mention everything, it loses some of its force in a case like this, where you have a judge who has given a lengthy judgment and a detailed judgment, the key factor of which is a decision of fact, whether what the intention of the donors was. And it is to be expected in our submission that the judge will have dealt with all the significant pieces of evidence upon which he relied, and dealt with all the evidence which he didn't rely upon, i.e. he says, no, that was contrary evidence, but I disregard that.
So that seems to be a submission that the longer and more detailed the judgment, the easier it is for you to succeed in this court, which seems counterintuitive.
Not necessarily, my lord, it's simply this, that the longer the judgment, again, it depends on the issue. A long judgment may deal with hundreds of issues, tens of issues, but this judgment was principally dealing with, say, the first 150 paragraphs, principally dealing with with issue 1. And we simply say that, all we say is simply you would expect in that the judge to have dealt with the significant pieces of evidence which he regarded and relied upon, and those that he disregarded. That's the point. It's simply an island hopping point. I don't say it makes my task any easier, but it somewhat draws some of the force from the island hopping point in the sense that, well, I criticise this, I can attack the judge's finding of fact on this because he relied on this evidence and he wasn't entitled to rely upon that. You can't then stand back and say, oh, well, there's lots of other evidence he relied upon and he could have relied upon, didn't mention. That sort of argument won't really wash, we submit, in a case where there's been a reserved judgment which is lengthy and detailed. I'm not saying it's completely ineffective, but given a judge, for example, who gives a judgment at 4:30 in the afternoon orally, that argument might well have some force, because given the exigencies of the situation, as we all know, as appellate authority, the judge can't be expected to deal with every relevant argument and every single piece of evidence in such a judgment. But that loses some of its force, I say, in a case such as this. My lords, I move on now, and I want to deal first of all with, before he gets to the November 1994 meeting, the judge deals with two aspects of the case, which he relies upon in arriving at the finding. And I'm looking at particularly at paragraphs 63 to 77 of the judge. And he deals specifically with two aspects, we would submit. The first are the Dewsbury accounts, and he deals with those at paragraphs 65 to 67 of his judgment, which is at 146, divider 10, whole bundle divider 10, 146. And the point he makes is a fair one, in that you can see the accounts themselves, the relevant accounts, in supplemental bundle 3, dividers 156 and 157. And it's true.
Do we need to send this up or not?
Well, yes, turn the 156 up, please. I might as well, because it's very brief. At 156, divider 156, page 622, are the accounts. And they are for the year 31st December 1996. And if you go to page 627, you will see, and they were prepared in, it's not in dispute, October 1998. So some years in arrear. And you'll see 627 for the year as at 31st December 1996. The London land is shown as an asset in the balance sheet of the Dewsbury Trust. And if one then goes on to 633, which is the equivalent provision, we don't have the 97 accounts, but we have the 98 accounts. And you will see that the equivalent for the years 97 and 98, we can see that from the comparison. The London land is not there and does not appear subsequently.
Is there any evidence as to where the donations and collections came from, what they represent on page 625? There's a very big spike in donations in 1995.
Yes, there was no evidence that I can see about that. I'm not sure it was gone into, but yes.
The previous year appears to be 77,000.
Yes.
The following years are much less, but that year was 685,000.
Yes.
No evidence about that.
There's no. I don't believe so. No. And the judge, perhaps understandably, says deals with this at 65 and 67 to 65, 67 of his judgment. And he makes the point, well, although it appears as an asset in the Dewsbury accounts for 1 year, it disappears for the subsequent years. We would make
the important point he makes is at 67, which was his assessment of the probabilities, is the asset was added because the Dewsbury trustees thought they were getting it, removed because they knew they had not. And there's no ground of appeal challenging that conclusion.
No, well, it's in the accounts, but that's the point, and it comes out of them.
But it's the inference the judge makes as to the probable explanation for the document that matters.
Yeah, well, I accept that. We would simply point to this. At least someone in 1996, which was the year the land was actually purchased, thought they were getting it. Secondly, I mean, the judge says paragraph 66 in the middle there, apart from Abbey Mills and the property of Christmas Street, the evidence before me does not support the proposition Dewsbury Trust owns any property saved in Dewsbury. That's not correct. The evidence was, and I'll take you to in a minute, the Leicester Mosque and the Blackburn Mosque were both owned by trustees holding it on trust for the Dewsbury Trust. Although I accept they don't appear in the Dewsbury accounts. And of course, the accounts are evidence of what the donee thought potentially was the case. And the relevant test, of course, is what the donor thought. All of the accounts post-date, the drawing up of those accounts post-date the acquisition of the property. And perhaps a seat of the pants point, there are no accounts at all for the London Trust. And
where does that take you?
Well, I'm trying to deal with the point. I'm building up. It takes me to paragraph 77, actually, on the judgment. I'm dealing with.
Just on the very specific point.
Yeah.
Come a certain point, it's apparent that the London end are not accepting that this is held for Dewsbury.
Yes.
And that's not just recently when, as I understand it, there's been a religious
No, it's not. It's
schism.
before the schism, yes.
So even by, is it 1998?
Yes.
The London end are saying, no, Dewsbury
Yes.
isn't.
Well, certainly C1 is saying that, and there's some evidence that other people in the London community were saying that, yes.
And the solicitors for size have got that message.
Yes, they get it eventually. I'll take you to the correspondence. 'Cause they're initially told it's the Dewsbury Trust.
No, I follow that.
Yes.
But at any rate, this is not a recent idea. So do you get anything out of the fact that there are no accounts then produced? I mean, the idea was around, on any view, by 1998.
Well, I don't have to, I say. What I'm trying to do is neutralise what the judge was saying here, that somehow this is probative. The fact that they appeared in the accounts for Dewsbury and then disappeared is somehow probative of the relevant attention. We say it's not. But he then goes on. I mean, the case put at trial by the defendants was that there would be some sort of assumption or presumption because of Dewsbury's leadership role. There would be a presumption that the donors would be giving to the Dewsbury Trust because the Dewsbury Trust owned other mosques and because they had more than simply had an administrative role as well as a spiritual role. Now, the judge rejected that. I say and part of his rejection of that is his finding, as I've just pointed out. He says, well, there's no evidence that Dewsbury owned other mosques. I accept they're not in the accounts, but if you look, for example, at the Leicester Mosque, can I ask you to go to supplemental bundle 3, please? It's 150. think you've got it. You may have it open with the manuscript.
Which tab, sorry?
I'm sorry, it's tab 150, page 599.
Yeah.
See, that's the Leicester, transfer of the Leicester Mosque in 1998. And you'll see that the transferees are four individuals as trustees of the Anjuman Islam al-Muslim of UK, registered charity 505732. That's the Dewsbury charity. And if you go on to page 619, which is divider 154, you will see that's the registered title. Certainly as at 2008. And if you then, just dealing with the Blackburn Mosque, if you look back at divider 147, and that's page 578. And you will see that's the transfer, 6th April 1993, transferred to four individuals as trustees of the Anjuman-e-Ismaili Muslim. And if you look at 588, that's unregistered land, I think. And if you go to 585, you will see it's a caution against first registration, dated 16th of January 2019, which of course post-dates the split or schism. And what is said in the Statement of Truth at section 10, 588, and I'm looking at the bottom three paragraphs there. At the time of the acquisition, legal title of the property was conveyed to the custodian trustees appointed by Ajmal Islam Muslimin Madrasa Tilmid Islam charity, with the beneficial interest vesting in the trustees of Blackburn Markaz and the benefit of Blackburn Jamaat movement. Charity did not make any financial contribution to purchase the property and no involvement in the fundraising. It was left to the trustees of Blackburn Markaz. Trustees of Blackburn Markaz in the process of arranging the transfer of the title. So the point is that after the split, the followers that don't follow the Dewsbury Mosque put it in a caution against first registration, basically saying, well, it's registered in the name of the Dewsbury trustees and shouldn't be. We're going to transfer. But it's just attacks the judge's conclusion that there's no. But I accept it's not in the accounts. The point is this: if one goes to paragraph 77.
Of the judgment.
Of the judgment, I'm sorry, my lord, that's divider 10, page 152. The judge's conclusion of all that is, in those circumstances, it was entirely up to the donors with what intention they made their donations or no. I accept that. But the point is that the judge was dealing there with the assertion that there was some presumption that everything was going to go to Dewsbury in any event, but he's saying no, it's up to the donors. We don't challenge that conclusion, but we say the donors clearly gave to Dewsbury and not to any new trust. And as we say, it's accepted, and the judge accepted, that Dewsbury had a spiritual leadership role. Dewsbury did own Christian Street, which was the original London Markaz, which had been administered and occupied and used by the local community for years. And thirdly, I suppose you can say the Dewsbury Trust at least existed and had existed for some time. The London Trust didn't exist until it was declared in 1998, the judge found.
On the judge's conclusion, there would have been some kind of trust before that.
That's right, yes.
There would have been a trust under which the trustees, as the judge saw them, had authority to declare trusts, which they then did.
That's right, and the judge accepted that despite the fact that the 1996 deed was in fact executed sometime in 1998, he nevertheless accepted it. I'll take it to this, the Matheson principle, that the trustees had authority on behalf of the donors to declare those trusts, and those trusts are the trusts upon which the donations were made unless someone challenges it.
Yes.
But we accept the judge's fact 77, that's the point I'm trying to get to, is that everything's up for grabs in that regard. And the judge was dealing with and rejected the submission that somehow some sort of presumption in favour of Dewsbury. Can I then, after that somewhat lengthy introduction, deal with the points I started out by saying I would make, and I'm going to deal with them in reverse order. And the first is the judge's treatment of the receipts. And in a way, you probably understand, having read, that the receipts only came into sharp focus relatively late in the day. And that was a reason we say the judge wrongly rejected them, one of the reasons. But so it came about in a rather roundabout way, but nevertheless, we got them. And I start off by dealing with the law on the issue because it's important we say to it was all agreed. In fact, I'm so agreed with a learned friend, I'm going to direct you to his closing submissions. If you go to Supplemental Bundle 3, Divider 162, and to 703, and it's paragraphs 112 through to 123, although I disagree with, challenge what he says in 123, but there's no dispute about the law that the judge had to apply. And my learned friend summarises it in his closing submissions of trial. And I don't say the judge misinterpreted or misstated it. My lord, I disagree with 1, 2, 3 because it discounts the receipts themselves. But the judge properly stated, though, if it goes back to the judgment, at paragraph 25, paragraph 25, paragraph 24, he sets out a passage from Tudor and Charities. And the third paragraph down, in that quote, at one level the law is clear, and he sets out, and then the learned editors set out 3 separate possibilities. And then the judge continues at paragraph 20.
Just pausing there briefly. I mean, the judge in effect finds for 3 at the end.
Yes, he does.
You find you favour 1, do you?
I favour 1 or 2, that's the point. I'm trying to make the judge got it wrong. In the next sentence, in present case, the act requires agreement, they should be held to purchase the donor, affect the choice between options 1 and option 3. I say no, we never said that. Our case is, and always has been, that these funds were donated specifically to purchase the London site.
Yes.
We never said otherwise. The question for the judge was not that. Was not whether, and I'll come to deal with that because we say he's mischaracterised that. He was led by my learned friend to mischaracterise it. It's not general donation to Dewsbury or specifically for the London Trust. That's not the question. The question was donation to purchase the site to the Dewsbury Trust or donation to purchase the site to a wholly new trust known as the London Trust.
Can we just unpack that a little?
Yeah.
I quite follow that on your case, the land was going to be enjoyed in specie for so long as it was held.
Yes.
But you don't go any further than that, do you? You say the trusts are the trusts of the Dewsbury Trust.
Yes, I have to. But the point is this, the trusts of the London trusts are identical.
And I follow that. As they're ultimately declared, they're identical.
Yes.
for
But that's
relevant
how they are.
purposes.
That's how. Sorry.
But you're not saying that these are restricted funds. It is not a 2 case on your case.
Well, it's a 2 case in the sense that we accept that the money it was expected that the money go to purchase the London land. And it might be a 2 case in the sense that had the money gone to Dewsbury and Dewsbury used it to fix the roof in Dewsbury, then the donors would have had a case to say, no, I gave the money for you to purchase the London land, not for you to fix the roof in Dewsbury.
I'm not sure I follow this, I'm afraid. On your case, they gave the money to the Dewsbury Trust
Yes.
on the terms of the Dewsbury Trust.
Yes.
Under those terms, yes, obviously the land can be enjoyed in specie while you've got it, but there's a power of sale
Yes.
of an unrestricted kind.
Yes.
Now, you can have a different case where land is given to a charity on a specific trust, so
Yes.
that it is a restricted asset. But that is not your case. and
No,
never
no,
has
I accept that. But my point is rather that if you make a contradistinction, what the judge did was say, well, look, you give it to the Dewsbury Trust, which ultimately is under the terms of the Dewsbury Trust, but the London Trust has the same terms. That's the point. As we say, it's a question of leadership.
The difference surely is that if you're right, the Dewsbury Trust can sell it off.
Yes, but so can
Whereas if the claimants are right, you can't.
no, not under the London Trust. They can sell it off.
They can, but you can't. It's the difference is the identity of trustees.
I accept that. Yes, that's the point.
The
But it's-
objects are the same.
Yes.
The powers are the same.
Yes.
But because the trustees are different, the way in which those can be exercised is in practice different.
Well, I accept it's a question of trustees. I think we put it in that it's a question of leadership. But it's not a question of the terms of the London Trust are different. In fact, the terms of the London Trust are the same.
And I absolutely follow
Sorry,
that.
my lord.
No, I absolutely
No,
follow that. But the judge is right, isn't he? That it's a choice between 1 and 3, because you're not contending for 2. You're not contending for an extra trust obligation on top of the Dewsbury Trust ordinary trusts.
No, I accept that right. But he then goes on to, if you look at 144, which is page 183. He says, the reasons to have come around, I will deal with the date of 1996 Declaration of Trust. Putting on one side, I conclude the objective intention of our donors members was that the 1.4 million tribute to purchase of land should be held to purchase C1 C2 deal, requiring the land to fund the building of the mosque, a community centre which they would be the trustees to maintain support said mosque and send each of the use of benefit. I reject the portion the intention was that it should be held for the religious and other charitable purposes date 97 trustee trust declaring charity. So he appears to making a distinction. Well, the Dewsbury Trust is a general trust. If you look at the trust, under the Dewsbury Trust, the terms you could technically, or the trustees could technically sell the land. But exactly the same is true of the London Trust, because, as we know, the London Trust, the 1960 Trust, was effectively cogged from the 1975 Trust. But yes, I accept my Lord Justice Arnold's point. It's a question of leadership, and that's what we say.
There's a slight sort of irony here, because it was open to the claimants on the judge's findings to declare different and narrower trusts in the event they didn't.
No.
But there's a sort of slight irony in you attaching so much importance to what they ultimately declare when they didn't have to do that on the judge's findings.
Well, they're foist on their own petard. We take a very dim view of the 1996 trust deed. We accept the judge found that it was entered into in sometime in 1998, which of course is directly contrary to the evidence given by C1. But they're foist on their own petard in that case. If C1 is stupid enough to cog out the 1975 trust deed and at some stage subsequently say, oh look, we entered into it in 1996, you know, he's foist with the terms of his own trust deed. And sorry.
I mean,
Maybe ironic, but we are where we are.
Certainly forensically. I'm not quite sure how far beyond forensically. You know, ultimately they opt for those trusts, but I'm not quite sure how much that matters.
Well,
that can't affect how one construes the donor's intentions at an earlier stage.
I accept that, but the point I'm trying to meet is that somehow there's a difference in terms between the two trust deeds. There is not, and somehow that I would accept that point, that it's a question of leadership. Were they giving it to these three individuals to hold on the same trusts as the Dewsbury Trust, but with them as trustees? Or were they giving it to these three individuals effectively to collect on behalf of the Dewsbury Trust, the trustees of whom were different, but the terms of which trust was the same? And I say, sorry.
So to that extent, you would accept that the identity of the individuals who held the legal title is critical?
Well, that's the issue that the judge had to decide. But it's not to be decided on the basis that the terms of the relevant trusts were different, and that somehow it's a choice between general Dewsbury and specific London. Because
Test it in this way. On your case, the money was collected for the Dewsbury Trust.
yes,
The point at the time at which it's been collected but not yet spent on anything, were the Dewsbury trustees bound to use that money to buy property in London, or could they use it for their other purposes?
I can't say they were bound, because I'm not saying it's a two case, but there would be an expectation. But I mean, suppose if I'm walking along the seafront in some seaside town in Britain, and I see someone collecting for the RNLI, and I give money, put money or tap my card these days, and I'm giving to the general charitable purpose of the RNLI. But if, for example, I'm in Blackpool, and they are collecting, they say, we are collecting to fund the construction of a new lifeboat station in Blackpool, then I'd give the money and I would have an expectation that that money would be used for the purposes for which my donation was sought. Now, if the trustees of the RNLI then used it to buy champagne for the chief executive's party, I would have a claim against them. I may or may not do, but it's not a relevant issue.
That's a bit of an answer. The question is, could it be spent at a neighbouring station, for example?
I suppose as a matter of trust law, technically it could. But we say that's the same with the London Trust.
I do follow the way you put it. I'm just remembering how you get these appeals where they say there's this child in Africa who needs such and such, and you then give the money. Well, I don't suppose the money goes to that child in Africa.
No, it's not. That's a general appeal. But I'm specific. If I say, I'm in Blackpool and I'm collecting for the construction of a new lifeboat station in Blackpool, I'd be fairly miffed if, as I say, they spent it on the chief executive's leaving party or some other general charitable purpose. That's perhaps not a good example. But the point I'm trying to meet, I'm sorry, rather too long, is to great length, is that we're faced with a choice between London and Dewsbury, but the choice is not on the terms of the trusts, which are the same in all material respects. There is a power for the London trustees to sell the land, and in fact it's greater.
Yes.
If you compare the two trusts. So I accept that, yes, it was a question of leadership in that respect. And so we're back to the law. What was the objectively ascertained intention of the donors? And my learned friend sets that out in his skeleton, we set it out in our skeleton. The judge accepted that, and that's what the judge had to decide. And we say that the key piece of evidence were the receipts. Those were the only pieces of contemporaneous documents which objectively showed to whom the donors were giving their money.
And so one would have expected them to be front and centre of your case from the outset.
Yes, I suppose that's right. They are front and centre of this appeal. But the fact that they...
So why are they not in the defence? Why are they not in the witness statements?
I can't explain that. I wasn't involved. But the fact is, that they're there. It may be no one fully focused on them. But it's not said they're forgeries. It's not said they didn't exist. And I'll shortly take you to the judge's findings as to what the receipts were and what form they were in. I accept one might forensically look at that and think, what's going on? But the fact is, and I complain about this.
Well, see, the judge's answer is they're not in the defence, they're not in the witness statements because nobody thought they were important.
Well, they're either important or they're not. Nobody thought they're important. It's for the judge to actually make a finding as to what was important. And the fact that they weren't focused, he didn't dismiss it. He didn't say, I'm sorry, I'm not admitting these documents. He didn't say it was inadmissible. They're admissible evidence. And the fact that the parties might not have focused on them until late in the day doesn't, we submit, undermine their force, undermine their cogency. You might think it's strange, but it wasn't said at any stage, or certainly the judge didn't, I'm going to exclude this evidence because it wasn't properly disclosed. In fact, some receipts were disclosed and they just weren't in the trial bundle.
The ones that were disclosed were much later, weren't they?
No, I think there were, some receipts had been disclosed as part of the general disclosure. I'm looking at Mr. Loveday. I think we explained this in our skeleton, but they weren't in the trial bundle. What happened was...
Just picking that up, Mr. Loveday can check this. My recollection, at least from reading the judgment, was that the receipts that have been disclosed in disclosure dated from later years. That might mean that they looked less obviously important.
That may be right. They are. There's no actual receipts which predate. I think the latest is we've got 272, which is 292, which is the receipt, which is July 1997 is the earliest one. And yes, there are receipts, and I'll take you to the judge's findings on this. The judge found that all the receipts, even those which from 1994, were in the same form.
Yes.
And that's the important finding. But there was... can I look at the receipts? I invite you to look at the receipts, and they say if you go to Supplemental Bundle 1, Divider 21, page 207. And this is how they focus it. This is you start at page 200, it's the witness statement of Mr. Ahmed, Mr. Shafi Uddin Ahmed, which is dated 4th of July, which I think was towards the end of the trial. In fact, And he exhibits the receipts. And if one goes to 207, one will see the first of these receipts, which is 292, and they're all numbered by hand in the top right-hand corner, or in a circle.
Well, not only that, they have printed numbers as well.
Yes, they do, but those don't appear to have... The point about the handwritten numbers is that they correlate to the loan books. There were handwritten loan books, and then the evidence was C1 periodically typed out a spreadsheet, or spreadsheets which show, and the numbers of the receipts we have correlate, the handwritten numbers in circles correlate exactly with the entries in the loan book.
Yeah.
And I think the evidence here is that 292 this is C1. This is his writing. And fairly obviously you will see that the receipt is Anjuman El Islahul Muslim of UK. It has that's the Dewsbury title, there's no London in there. You will see it has the Dewsbury charity number and the Dewsbury address. It's printed out, and you will see printed, not that, is London New Markaz. And this is a receipt for Shamsuddin, and it's £104,000, and it's signed by C1, and it's dated 2nd of July 1997. And you will see the cheque over the page, and it was paid in, we can see, it was paid into the bank account at Streatham, which is in the name of Dewsbury, the judge found, the UK, and the addressee of the cheque is UK, which is the Dewsbury charity, it's not the London charity.
You're not running the case, you made it very clear that this is a category 2, judge's judgment of 24. But just so I can understand, what's missing? What would you need in addition to what we have in this case to make it a category 2 case?
Well, I don't know. I mean, I don't have to run it as a 2 case. All I have to do is show that it was donated to Dewsbury. Whether it was donated as a category 1 case or a category 2 case doesn't much matter, we would submit, because that's not what the judge had to decide. It could be run as a category 2 case. And it might make a difference, I suppose, to the CPRE. But that's not what the judge was deciding. And so that's why I'm slightly chary about addressing it.
For any charity trustee, it makes a big difference whether it's a restricted fund or not.
Well, my lord, I accept that. All I'm doing is take you to the evidence.
Yes.
And the issue which the judge had to address was whether it was these donations, objectively assessed, were made to the Dewsbury charity or to a new charity, subsequently called the London charity, to a whole new charity. And whether the donors anticipated that the money would be used to buy the London site, and indeed it was. Now, whether that was technically a trust in specie, that a special trust, you had to do with that, or whether it was generally to Dewsbury with the expectation, which was borne out, that the sums would be used to purchase the London site, I'd say it may be highly relevant in other circumstances, but it's not what the judge had to decide. So I'm sidestepping that issue, but I do say it's not particularly relevant, or not for this particular issue. But it's clear we would submit, if objectively viewed, who are you giving that money? That's a very large sum of money, £104,000, and you're getting a receipt, and you might think that if you're giving such a large sum of money, you might expect...
Is this a gift or is it a loan?
This is, it's called if it says Kardi Hasara, it means a goodly loan.
Yeah.
So that's a loan which you
Not
might...
not a gift.
It's not a gift, no. I think the evidence was that the gifts were not recorded, but the loans were. Now, a lot of the loans were expected to be and were eventually written off. But yes, and I think the evidence was all the loans, I'll take you to, all the loans had their, were given receipts. And I suppose it might be said, well, if you're giving a loan technically as well, you might even more so, you'd be interested in to whom you're lending the money because you expect it back. But whether you're giving a gift, or particularly if you're giving a loan, you would expect the receipt to be accurate. You expect to know exactly to whom you're lending the money.
Just to be clear, you accept, do you, that on your case, Dewsbury had an obligation to repay this?
Yes.
Because there is evidence, as I understand it, that Dewsbury was reluctant to take on financial responsibility.
I accept that, but the money was paid into a bank account in Dewsbury's name.
Yeah.
I mean, and the point is this: the key question here is objectively ascertained to whom were the donors giving the money, or the lendee. I mean, the judge rightly said, well, it didn't matter whether you were a donor technically or a lender. It was your, and we say it's absolutely clear, crystal clear. You're giving it to the Jews. You're giving it, lending it, donating it to the Dewsbury Trust, and that's July '97. If you go to 209, you will see receipt 397. Now that's not until January 2012, but is in the same form. That's £20,000. Again, clearly headed the Dewsbury Trust with its charity number.
Now, you drew attention when we looked at the earlier one, and we see it even more clearly here, to the fact that the printed form includes the words London Newmarket.
Yes.
Now, was there any evidence as to who and in what circumstances had directed the printing of the form with those words on?
I've checked that. I think the judge makes a finding of that. He deals with it.
I think he concludes that this dates from an earlier period.
Yes.
When they were raising money in anticipation that perhaps something would happen. So I don't think he thinks it's specifically for this mosque.
Well, it's for New London. Yes, I think there's a 1980s. It's 86. Paragraph 86 of the judgment. Sorry, it's 92, 93, 96. If one goes, it's paragraphs 92 to 96 of the judgment, he deals with that. I was going to take you to that eventually anyway, so you might as well.
And it's especially 96 at this point.
Would you accept that it's somewhat significant? I mean, one can debate how significant. Would you expect that it is at least of some significance that on this finding, the receipt book comes from an earlier period and specifically from Christian Street?
The receipt book?
Yes.
Well, no, I mean...
I'm looking at paragraph 96. He says, I find the original receipt book did come from Christian Street and had been printed in the 1980s.
Well, no.
So do you say those I mean, you're not challenging those two small findings of
No,
fact.
no.
But do you say they're irrelevant?
Well, yes, they're relevant in the sense that they support the judge's finding that this was the form of receipt which was given post-November 1994. There was a pre-existing book of receipts which had been printed in respect.
Exactly, and therefore it might have been used for convenience.
Well, it might have been used for convenience, but the judge has to objectively, the test is objectively, who would a reasonable observer think the donor was giving his money to, his or her money to? And Mr. C1 is an accountant. He's not stupid. And the idea that you can somehow, as a matter of convenience, give a receipt for £104,000, oh, it doesn't matter, I'll give it, for a loan, is ridiculous. Whether or not it's used for convenience, if one needed.
I quite understand. Your case is very straightforward. The words say what the words say.
Yeah, and an objective.
And they're unambiguous. Yes. I quite understand that. But if it were a pure question of construction of the document, then your case would be open and shut. But it's not a pure question of construction of the document, is it? Because it's a question of, as you say, what was the intention? Mm. And I think you're accepting, but if you're not, please tell me, that it's relevant to that inquiry to ask why the document was being used in the first place and what light that might shed on the intentions of those using it.
Well, why the document was being used, yes, and there's a number of ways. One, it's being used as a receipt. Now, it might be, oh yes, look, we have a bunch of these ready-made receipts, let's use those. But one can say, okay, well, if one's collecting £1.4 million, and one has, if C1's right, one has had a declaration in November 1994, no, we need a new charity, then one might expect them to use a different document.
So on your case, they should have either had a new receipt book printed,
yes,
or they should have manually corrected every receipt that they issued from the existing receipt book, or they should have handwritten
yes.
receipts.
Yes, not difficult for the sum of £104,000.
Not difficult as a one-off, but if you're doing it repeatedly, perhaps a little more.
Well,
if you're lazy.
You have to be very lazy indeed, or just not care. But I don't accept that if you're collecting, and we'll look at the loan books now, hundreds of donations, some of which are very large indeed, some of which are small, for £1.4 million over a period of 2 years, that one, as a matter of convenience and without thinking, uses the pre-existing receipts without them meaning anything.
Can I just think about one aspect? I mean, the receipts we actually have are relatively late, and you were showing us one a moment ago, dating from 2012, yes. Was it? Now, back in 1998, plainly the London end dissociated itself for the purposes of the conveyance from Dewsbury. Now, when we find money being provided in 2012 and the same receipt being used, on your case, presumably, it's Dewsbury that's getting the money and undertaking the liability to repay.
Yes, well, that's what the receipt shows.
But just thinking it through. Now, on the one hand, one might say, well, if they were willing to use the receipts at that stage when plainly there was seen as a distinction between Dewsbury and London, well, that means that they didn't attach much importance to it. Alternatively, might you say, I don't know, well, back by 2012, people weren't quarrelling, the schism hadn't yet happened, fine, they meant the money to go to Dewsbury.
Yeah, but I mean, by 2012, the London charity hadn't been registered yet. It wasn't registered in 2018. And there was no schism in until, I think, 2017, when that developed.
So this money would have been lent to Dewsbury, and for what it's worth, one would expect that to show up in its accounts because it was undertaking a debt.
Well, if it knew about it, yes. I mean, but the point is, perhaps I'm banging on too much about this, it's the intention of the donor,
Yes.
which is key, and the objectively ascertained intention of the donor. And particularly when one's dealing with events 28 years prior to the trial. The receipts received in that form are key, we would submit, fairly obviously. And there was evidence of this. I accept that there's few receipts. I mean, I haven't taken you. I'll take you, if you look at, for example, just to make that up, if one looks at dealing with 292, which is the receipt we've looked at, that's at 207. The cheque is 208. You can cross-reference that in the various loan books. If you go to supplemental bundle 4, it's divider 175. Hope you have, it's right at the end.
No, my last one is 174.
I'm privileged. I have a 175.
I apologise. I'll get. Would you like a new bundle, or would you like just the?
I don't think I've marked this one, so probably it's easiest I can.
Let me get you. Sorry. Does my Lord Justice Zacaroli have?
I have, thanks.
I'm grateful.
Thank you.
Well, one goes, for example, to 1030, which is at divider 175. And sees that's one of the handwritten books you'll see awkwardly it's upside down, 292, 104, 133. So someone recorded that in handwriting. Then if one goes back at 1029, one sees this is the typed reconciliation that C1 does. And indeed, if one goes to 1034, that's another, and that's the same one, but 1035 is another version, an updated version. So one can trace certainly the receipts that we have into the loan books,
Yes.
both handwritten and subsequently typed up. And C1's evidence was that he had prepared those. As I said, he is, or was, an accountant. Just to take you go further, is the evidence that there was evidence even before the issue came into full focus. Again, we're doing a bit of, you need to look at supplemental bundle 1 and supplemental bundle 4. And what starts with supplemental bundle 1, divider 1, page 19. Page 9, and this is the evidence of Mr. Rahman, and we'll return briefly to that because there is relevant evidence, paragraph 9. But he says, paragraph, I personally donated my wife's gold necklace. I gave the necklace to Ali Sabe, who's a London brother. Since purchase, I've given several small donations because more money is needed. All loans were given receipts. So he says that. The first claimant himself, C1, paragraph 519, which is the next divider, page 22. the last line of 519. And if they want receipt, I'll bring the receipt for them because the loan receipt is very important. Staying in bundle 1, divider 10. Sorry, it's not divider 10. Sorry, divider 7. And this is the statement of Mr. Cadwallader. One sees that on page 79, page 80, paragraph 10. Although I asked for loans, people also gave donations both the loans and donations through the cash cheque. If it was a loan, I would take this to Ghulam Patel, who would give me a receipt, and then I would give the receipt to the person giving the loan. Again, if you're in divider 6, Mr. Malji. At paragraph 18, which is at page 71. Again, starts at 69, paragraph 71, paragraph 18. Then whatever the local brothers raised, they brought to us. They brought the cash, they brought the cheques, they brought the money. I was not aware which bank accounts the cheques were paid into, as I was not responsible for the money. That was done by another London brother. Were loans given by whoever the locality. London Shore gave them receipts to prove they got the loan. And then can we go to supplemental bundle 4, please, which is the transcripts. And if one goes to divider 170, and it's the evidence of Dr. Holander on day 7 of the trial, and he's at 982. He was one of the defense witnesses, and he was being cross-examined by my learned friend Fowles. And if you go to page 982, it's internal page 751, about line 12. Question: but you were told you were raising money to buy the Abbey Mills Mosque for London. Answer: under the Anjuman-i-Islami Muslimin Dewsbury, that name. Our receipt was in that name, and I have been told that Dewsbury, that is such thing. Question: can I ask you, what receipt are you talking about? Answer: you know the one you get the money, they give you the receipt. I'm talking about that money. The receipt was given the name of Anjuman-i-Islami Muslim of Dewsbury. That name, the receipt came. And we've not seen such a receipt. Answer: I do not have that with me. That is what we were given at the time. So clear evidence before this all got. And if one goes to back there to divider 164, and this is the evidence of Mr. Cadwallader at page 824. Page 1, internal page 115. Line 17, and again he's been questioned by Miller Friends of Westwood. Question: you said paragraph 7 you remember collecting a figure of about £50,000 families around you for Redbridge. At the meeting I stood up, I was the first one who stood up and said we want to buy this place. From the Ilford area in the name of Alan, in the name of God, we collected £50,000, managed to collect more than that. You personally collected reached 50,000. Me and my colleagues all together, not my own, me and my colleagues from the Ilford area, we went to the brothers and requested then we want to be able to buy the markers and we need the funds. Did you keep records? Of course, all the money was given to Mr. Ghulam Patel, who was at the time of the markers. He has the records right down in his book. I personally paid £2. He gave me a receipt as well. Those who collect a receipt he was giving to them, along with the unclear silver there. Again, so evidence from witnesses called by both sides that receipts were given, and that's before, that evidence was all given before the witness statement that exhibited the relevant receipts. The first claimant was then recalled to give evidence, and his extra evidence is in supplemental bundle 1, divided 4, page 60. And he specifically addresses the paragraph 6. Sorry, it's page 59. Sorry, it's supplemental bundle 1, divided 4, page 59. It's focusing on page 60. And it's paragraph 6 onwards. My Lord, as we'll see, the judge rejected his evidence that he had given out receipts on blank pieces of paper. But he's cross-examined about that. And again, we have to go back, I'm afraid, to supplemental bundle 4, divider 174. Page 1019. He's questioned at the outset internal page 1036, which is at 1019 of our bundle. The question, at the final sentence, you say, if they want a receipt, it's referring to people giving money towards that. So I will bring the receipt for them because the loan receipt is very important. Yes. Can I take it to remain your evidence the loan receipt is very important? Answer, yes. And then just over the page, internal page 1038. Sorry, at the bottom he's in. The question is, beneath that it says Charity Commission registration number 505732. That's the registration number of Dewsbury Charity. Answer, yes. Question, you knew at the time the receipt was issued. Answer, yes, it was for London New Markaz. It's also written on the receipt. Question, just concentrating on the question, Mr. Mohammed, you knew at the time of this receipt the issued for the charity registration marker 505732 was the registration number of the Dewsbury Charity. Is that correct? Answer, yes, we were using this because, can I explain something? And then I'm going to flip over to internal page 1040. Line 6. Question, the reference London New Markaz is in printed text, is it not it's not handwritten, is it? Answer, it was printed, yes. So do you accept, Mr. Mohammed, that the receipt book must have been printed for the express purpose of London New Markaz? Yes, this is what it says, yes. You see the circle of the receipt? Yes. Number 292 written in Manchester? Yes. That corresponds to a number in the loan book you maintain? Does it? Yes. Just to confirm, that's your signature, is it not, in the receipt? Answer, yes, my lord. And then down to the next page, 1041, line 8. So questions 3. What I'm going to suggest to you, Mr. Mohammed, is that, in fact, any receiving the receipt where clearly states the Anjuman Islam was the UK, 50572, we understand they were giving the money to the charity. You accept that? Not today, I do not accept this. They gave it to us at London Markaz, certainly would ask us to make sure this goes to London. It was written in London, we were using the store for this book. Can I ask you please go to paragraph 10 of your witness statement? Say in the final statement, nobody ever asked about the receipts. That is right, is it not? Nobody ever queried what was written on the receipts when you gave them. Yes, when we gave them, they never thought about it, and ourselves also, that people are giving money to Dewsbury, they were specifically given to London Markaz. Could I ask you to answer the question, please, Mr. Mohammed? Nobody ever actually queried with you, did they, what was written on the receipts? Yes, never queried, once they see London on the receipt. So the evidence was eventually dragged out of C1 that no one ever queried what was on the receipts. And you've seen what the judge found in relation to that. And we say, perfectly entitled, indeed inevitably finds that these were the receipts that in that form were given right from the start. But, and he rejects further lies from C1 about the giving of blank sheets of paper. Very obvious in the absence of any other contemporaneous documentation that this is absolutely key evidence as to the intention of the donors to whom they were giving the money. Then one looks at how the judge sought to sideline or sidestep the receipts, and we say it was illegitimate. He starts at paragraph 89 of his judgment, which starts at its core bundle, divider 10, page 157. Number of the claims witnesses volunteered in their states when loans were made, not only recorded in the loan book, but receipts were supplied. I'm thinking of Mr. Mohammed, Nasher, Cadwallader, Mohammed Abdul Rahman, Maldi, Mohammed Idris Fati, Yaqub Ali, Mohammed in particular. None of them indicate on whose behalf the receipts were given, and it's natural to assume that they thought they were given by or on behalf of the London Shore or London trustees, as indeed they must have been. Some of them raised large sums of money. Those witnesses were not asked about it, of course. That is not a conclusion that the judge was entitled to reach. There was no evidential basis for that whatsoever.
Do you mean for the it is natural to assume
Yes.
part?
It's not natural to assume. When one looks at the receipts, it can't be said it's natural to. It's natural to assume they're given on behalf of who it says they're given on behalf of. That's the Dewsbury trustees. The Dewsbury Trust.
But surely at that stage he's looking at the position prior to the receipts having emerged.
Yeah, well, he might have written that part of his judgment prior to that, but the point is...
No, you can tell that because of paragraph 92, he says what happened on the 9th day of trial.
Yes, but it can't be right that he comes to a conclusion at any stage. He has to look at all of the evidence, no matter when it was produced. That's the point. He might have, prior to the focus on the receipts, been of the view, well, the only evidence
But why is it not a fair reading of what the judge is saying? That in 89 he's setting out what the natural assumption would be absent the documentary evidence that came in later, and then when the documentary evidence comes in later, he then says, well, does that change the position?
Well, with respect, I don't think you can say the position would have been absent the documentary evidence, because we got the documentary evidence. And you can't come to a conclusion that, well, if I ignore the receipts because of what I found happened at the November 1994 meeting, then I would assume that the donors were giving to the London Trust. But you can't ignore the receipts. They got the receipts. They're contemporaneous documents.
I mean, the difficulty is that the judge hasn't expanded on what he means exactly. I mean, one can see various possible things he might have had in mind. I mean, for example, to the extent that it was witnesses for the claimants saying, we got receipts, and they were explaining that they didn't intend the money to go to Dewsbury. Presumably, when they gave evidence, they didn't have in mind that the receipts showed that the money was going to Dewsbury. Consistently with their evidence, they must have assumed that the money was going to London.
That might be right, but that might be their subjective view, and that's an irrelevant consideration. But yeah, it's difficult to say. I suppose I might be criticised for being overly critical of the judge on this, but at the end of the day, one has the receipts. The natural assumption we would submit is that the receipts accurately reflect the intention of the donors, because that's what the receipts say. And even if the intention of the donors was different from what the receipts said, they didn't say anything about that. and the subjective intention of the donors is irrelevant. If I give money to the RNLI, or I give money thinking I'm giving money to the RNLI, and I get a receipt on behalf of Guide Dogs for the Blind, and I look at the receipt and I think, well, I'm giving my money to the RNLI, I'm not going to say anything, I ignore it. It's irrelevant. The objective view is that I'm giving money to Guide Dogs for the Blind and not to the RNLI. So we take issue with that natural. So it's natural to assume only if you ignore the receipts and concentrate on what the judge found took place at the November 1994 meeting. But once you look at the totality of the evidence, it's not a correct statement. And even if it's what they assumed subjectively, it's irrelevant. And then one goes to...
So is the point Judge makes in paragraph 90 about none of the defendants' witness statements having mentioned receipts, nor it being part of their pleading case. So on your submissions, that's irrelevant too, because once they come in, they trump everything.
Yes.
Yeah.
I mean, forensically, you might raise a point at, well, why not? But at the end of the day, if it's relevant evidence, it's relevant evidence.
And I quite see how you put it, Mr. Holland. But, and I think you would say, and probably rightly, that this doesn't matter. But as we see, these same receipts were used way later. And I think you were sort of implying in something you said a moment ago, well, Dewsbury might not even have known about these sums coming in. And yet you say, well, the money must have been given to Dewsbury because that's what the receipt says. And that can't have been the intention of the London trustees.
Well, one doesn't know.
But then you say the intention of the London trustees doesn't matter.
Yeah, well, I'm afraid I do come back. I mean, the key period is 94 to 96, 97, maybe into 97, 98, when the money was handed over, and when the property was contractually bought in 96, and thereafter it was, I think it was transferred, or in 98 was the application to transfer. But again, I come back to it, I'm afraid, the intention of the donors. Whatever might have been happening subsequently between the London community or certain elements of the London community and the Dewsbury trustees. Nevertheless, if take it back to the point, if I get a receipt from the Guide Dogs for the Blind, that's, unless I say, hold on, mate, I'm not giving it, cross that out, but the RNLI, then objectively...
What if you don't look at the receipt?
Well,
I'm serious. I mean, I'm very interested in your example because it does test the proposition, which seems to be legally common ground, that it's an objective question. So, on your hypothesis, the donor thinks subjectively that they're giving money to the RNLI. They hand the money over. It's a cash donation. They hand the money over. So at the point of the money being handed over, there's nothing to contradict their subjective understanding. Then, after the money is handed over, a receipt is written out in the name of Guide Dogs for the Blind. And even if they never look at the receipt, you say it doesn't matter.
Yeah, well, it's the same. My learned friend in his closing drew attention to the contractual principles and there's a scintilla temporis. If I give over cash and I see someone writing out a receipt, well, I'm expecting that to be a receipt. And if there's nothing said that I am giving to the RNLI, I just hand over the cash and get a receipt in the name of Guide Dogs for the Blind. Objectively speaking, I've given money to Guide Dogs for the Blind, unless there's some other circumstances. For example, there's a notice which says I'm collecting for the RNLI. Which might objectively challenge that.
I mean, I do follow that point. So, as you say, if you had somebody in the street outside the law courts saying, I am collecting for the RNLI, you gave the money and then were given a receipt saying it was going to Guide Dogs for the Blind, then the context would show that objectively that wasn't your intention, even though the document indicated otherwise.
Yes.
And the same idea, whether or not it actually has a practical application, must operate here, mustn't it? If the context were that donors could, for objectively ascertainable reasons, be expected to have been intending the money to go to something other than Dewsbury, the receipt wouldn't necessarily be determinative.
Well, in a one-off situation, I suspect you might, depending on circumstances, that might be the case, but it can't apply here. I mean, these donations were collected over years, and most of the donors would not have been at that. Even on C1's case, would not have been at that November 1994 meeting. The whole point was to go out and collect money from the wider London community to buy this land. Now, one might expect in such an organised pitch, an organised campaign, that the receipts would be accurately reflect the recipient of the donations and the loans. I mean, I say, if you
well, one might expect it. Might expect in what sense? Do you mean that you would expect the donees to hand out things that are accurate?
yes, and we might expect, if I'm handing over £104,000, I might look at the receipt and I might think, well, right, okay, that's the person I've got a receipt, it's a loan I'm giving. So who am I lending this money to? I'm lending it to the person who I get a receipt. It's a formal printed receipt which is filled out by hand. And you might say in certain circumstances, if, for example, I'm standing outside the law courts under a banner of the RNLI, and someone hands me over money and I give them a receipt for the guide dogs for the blind, one might expect, well, the context might tell me, objectively viewed, might tell me, yeah, well, there might be a mistake there, or the person who handed over the money is giving to the RNLI, but that's not the case here at all.
Well, the £104,000 is given by cheque, isn't it? So the
Yes, it
person
is.
must have been asked to identify the charity.
Yes,
Dewsbury
and
charity.
it's in the name of the Dewsbury Trust, paid into the Dewsbury Bank. I'm coming back to that when I deal with that.
Is there a breakdown of the extent to which contributions are made by cheque as opposed to cash, and does that matter? What if half the recipients pay by cash and genuinely didn't think about it, didn't look at the receipt, but those that paid by cheque must have known who they were paying to?
I don't know, I haven't focused on that, but the cheques must have been payable to Dewsbury because it's a Dewsbury bank account.
Yeah.
It's in the name of Dewsbury, so and we see the cheque, the £104,000. But whether it's cash or cheque, so the cheque is a Dewsbury, so you would think, right, well, I'm paying it into a Dewsbury bank account. But even if you don't know it's Dewsbury, if you get a receipt which says Dewsbury, and if you don't look at it, well, so what? The test is the objective observer standing right, hold on, you got a receipt? You might not look at it. Who do I think you've given money to? You haven't said, you've just given it to this, it's for the London Marquaz. Right, stop. Got a receipt, what does it say? It's an objective test. I come back to how the judge deals with it in paragraph 96. So he finds for us, and so he finds that these were the receipts, they're all in this form, they're all handed out. But it's about just over halfway down the page. Well, he says, I accept, however, that given that it did matter, neither he nor anyone else could have regarded the reference to the Dewsbury Trust on the receipts as being of any significance in relation to funds raised for the purpose of acquiring the Abbey Mills site. Now we say, A, there's no evidence at all to support that.
Do you mean that there was no evidence that it mattered?
No.
That it was seen as mattering?
Well, if you accept the evidence of C1 as to what happened at the November 1994 meeting, his evidence was that it mattered.
Yes.
But the point that he then goes on, because given that, what was on the receipts couldn't have mattered. Well, there's no evidence at all that anybody, most of whom were not at the London the night for me, ever challenged what was on the receipts.
And I see the point from the point of view of the donors, but it can't matter to Mr. Mohammed. I mean, he did think that there was a distinction on the judge's findings between London and Dewsbury.
He's a liar.
Well, that comes back to your last point.
Yeah.
But on the assumption that you can't overturn the findings in relation to the November 1994 meeting, Mr. Mohammed saw a distinction between London and Dewsbury.
Yes.
So when he was handing out the receipts, he can't subjectively thought that he was acknowledging that the money was to go to Dewsbury.
What one doesn't know. I mean, the judge rejected his evidence that it didn't matter. But
well, the judge said it accepted his evidence that it did matter.
But my lord, even if Mr. C1, if you accept his evidence that it mattered to me, but I just handed out the receipts willy-nilly, that is irrelevant. The question is, one, what the donors were giving. I say, Mr. C1 could have thought that, I'm collecting this money on behalf of the guide dogs, but if he gives out a receipt which says Dewsbury, that's to whom you make the money. So subjectively, the views of C1 are irrelevant to the test the judge had to apply. And there's no evidence that anybody queried what was on the receipts, some of which were for very large sums of money. So that, one, there's no evidence that we can come to that, and whatever C1 might have thought, and secondly, it's the wrong test. And he then, I think we've already made this point, he then focuses on it came to focus late in the day, it wasn't pleaded, it wasn't that. I accept that, but that doesn't render this evidence, it doesn't undermine the evidence in any way. You might raise a query, but it doesn't undermine it, particularly in a case where one's dealing with oral evidence of a key meeting which was 28 years before the date of the trial, which was undocumented. And even if you could say, well, it's rather strange that they didn't focus on the receipts. Nevertheless, they were there, they were contemporaneous documentary evidence. And the fact that they were only focused on late in the day cannot go in any way to undermine them. You can't sideline them like that. So we would submit that that's the first point. The judge should have, he cannot sideline, the receipts were clear, he made findings in relation to them, and he cannot, it was wrong to sidestep them the way he did. I'm moving on to my second point now. And we've already discussed this, I think, a little, but the key here is the definition of issue 1. That's what the judge was deciding. If you look at, and the point is, it's either Dewsbury or it's London. If you go to issue 1 is its core bundle divided 22308. And list of issues agreed between the parties, and you see there's definitions. 1. In the circumstances, with what objective intention on the part of the donors and lenders was 1.4 million contributed for the purchase of the land? And this issues POC 1 to 2. POC is a reference to the re-amended fix of claim, which you will see at page 244, which is at divider 16. And you see paragraph 2, the claimants and the 14th defendant hold the land on the trusts of the charity known as the Anjuman-e-Islam Muslimin of London, UK, the charity, contained in a declaration of trust dated 5th November 1996, which was declared on the implied authority of donations and loans received by the claimants for the purpose of the spirit of the gift of acquiring the land to fund the building of land. So, the issue, as I've said, is either London or Dewsbury. And I've made the point, I'll take you to the terms of the trusts if you want, but they're not identical, but substantively they are the same.
This suggests there's a big difference, which is that the London Trust is to benefit the London community.
Well,
Is that right? Is that what the trustee says?
Well, no, I'll take you to that, if I may, in that case. The 1975 deed is at Supplemental Bundle 1, Divider 22, page 216.
Yes, my question was directed at the London Trust, not the Dewsbury Trust.
All right, the Dewsbury Trust, the London Trust is at Supplemental 268, 346. And like I say, if you want to do a comparison, you can. I have a comparite document, but if you look, keep your hand. It's bundle 1, page 216. But if you look, there's the declaration, 5th of November, and they recite the conveyance. 2, the said premises were purchased by the trustees with the intent that a mosque and other buildings should be erected thereon, or in some part thereof, and that thereafter the place should be used for religious and educational purposes by persons of the Sunni Muslim faith. The trustees are tasked with declaring religious and educational other charitable trusts. 4, cultivate further land and also cash investment chapels may from time to time be donated or otherwise acquired by trustees, but subject trustees of this deed. Then, Part now it is deed witnesses for the purpose of effectuating the desire herein for expressed consideration for the trustees here declare they stand seized, possessed, and said premises any capital monies coming to the hands of the trustees, also such further land, cash investment, chattel donated or acquired aforesaid, on religious education, other charitable trusts, with subject to other powers and provisions here and to declare concerning the same. Trustees shall permit the said premises and any buildings erected or to be erected to be used, occupied, and enjoyed as a place of public worship of Allah and the preaching and teaching of shapes the Muslim faith, according to the principle of usage, timing of the Muslim faith, the instruction of children and adults for the promotion of such religious and other charitable purposes. Trustees 2. Trustees may sell or convert or concur in the sale or conversion of any land, investments, and chapels made from time to time created or otherwise acquired by the trustees. And then if you go to 6, the trustees shall, whenever so required by special issue, sell, mortgage, or demise the said premises or any part thereof for any term of years, exchange the said for any part thereof. The premises. 6A, trustees shall stand possessed of the money arising from the sale or any money which may come to their hands in connection with said premises in the nature of capital after paying all costs on trust to lay out and apply the same in towards the enlargement, rebuilding, improvement, or repair of any building on the said premises, or in towards the purchase of other premises, or at a tenure towards any of the other purposes, objects, presents.
Perhaps for completeness, we should compare the
Yes.
Dewsbury Trust.
And that is at divider 1, supplemental bundle 1, divider 22, 216. Again, it's not identical, but it's clear in the judge mind that it's
borrowed.
Yes, it is. Or rather, the first document we've looked at is borrowed from the second.
Well, I suppose one distinction, I know you'd say it doesn't matter, is the said premises are different.
Yes, they are. But the trusts upon which the said premises are held are the same. And indeed, if you look, for example, I say that
So if we assume that the money is given to Dewsbury to be held on these trusts, what would be the relevant trust?
Well, the trust would be, there's a trust of other land, isn't there? If one looks at, there's the recitals, which again refer to the said premises, which are the Dewsbury. And 2, the said premises were purchased by the trustees. The intent that the mosque and other buildings should be erected there on some part, and thereafter the same should be used for religious and education purposes. Trustees such as that. And then it's contemplated further land and also cash invested channels may from time to time be donated to or otherwise acquired by trustees upon with the subject to the trust powers and provisions of this deed. And then there's the witness bit.
So 1 is the bit dealing with enjoyment of the species, so to speak.
Yeah.
Now, does that apply to subsequently acquired land?
Well, yes, if you look at, I think it's about 1, 2, 3, 4, 5, 6, 7 lines up from the bottom. The committee hereafter refer to such premises being known as the Madrasa Talim Masa, in particular shall permit the said premises and any such buildings as aforesaid, and that refers back to, I would submit, the recitals.
So where are the buildings aforesaid in the recitals?
Well, we would submit, if you look at recital or recital 4, it's contemplate further land and also cash investment chapel may from time to time be donated to or otherwise acquired by the trustees upon with and subject to the trust powers of this deed. Now this deed witnesses for the purpose of effectuating the desired import expressed in consideration foregoing, trustees hereby declare that they stand seized and possessed of the said premises and any capital monies coming into the hands of the trustees, and also any such further land, cash, investment, chapels donated or acquired as aforesaid upon the religious education and other charitable trusts with and subject to the provisions hereafter declared.
Now, in all that, there's no mention of buildings. There is a mention of buildings in recital 2.
Yes.
So it rather looks as though the aforesaid, the said premises and any such buildings as aforesaid are the buildings put on the Dewsbury site.
Well, the Dewsbury land is defined as the said premises.
Yes.
Which clause 2? Yes. I've been asked to show you clause 2, and I'll show you clause 2 and clause 6.
Yeah.
I've been struggling with clause 2 because the first line is pretty well disappeared.
I think it says the trustees may sell or convert or concur in the sale or conversion of any land other than the said premises, investments and chattels as may from time to time be donated to or otherwise acquired by the trustees as aforesaid, and shall do so if directed by the committee, shall apply the proceeds of such sale or conversion as aforesaid, and any cash other than cash coming to hands of trustee in accordance with the direction of the committee for any other charitable purpose declared by this deed.
So where you want to sell the Dewsbury land, you have to apply the special resolution procedure.
I think that's right. The equivalent provision in clause 2 of the London doesn't restrict it to, it says the trustees may sell or convert or concur in the sale or conversion of any land. So there's no special restriction in the London deed to the London premises.
Okay. It's not restricted to the London premises. However it works, you see a special resolution procedure in 6, don't you?
Yes. Well, yeah.
So if we assume this money was given on the terms of the Dewsbury Trust,
Yeah.
On the face of it, clause 1 does not apply. And you get clause 2, but without the restriction relating to the said premises.
Yes. My point is rather that there's no material difference in some between the terms of the two trusts, and that the two buildings are held on exactly the same trust. There's a power of sale in the 75 deed as there is in the 96 deed.
But it makes, supposing, I mean, in relation to this land, there is a difference, not merely in the trustees, but in the trusts affecting the land. Because if it's the Dewsbury Trust, Clause 1 does not apply.
Yeah.
And if it's the London Trust, Clause 1 does apply.
Well, but it says, the recitals in the 1975 deed do say, it is contemplated further land and also cash chattels may from time to time be donated or otherwise acquired by trustees on with and subject to the trust powers provisions of this deed. So any land that's after acquired is held pursuant to the terms of the trust.
But not Clause 1.
Well, except Clause 1 doesn't specifically doesn't mention any other land, but I would submit that if one looks at Clause 4, it does apply. Any other buildings acquired are held pursuant to the said trusts, and I would say that does include Clause 1. If you acquire further buildings, you're holding them as a place of worship, we would submit.
Well, Clause 2 is the important one, which is that any other donations are held on the charitable purposes. Where do we see the charitable purposes as such?
I think they are well, it's Clause 1 is the charitable purposes, isn't it? Trustees should permit said premises and any buildings erected to be used, occupied and enjoyed as a place for the public worship of Allah and for preaching and teaching the precepts and teachings of the Muslim faith according to the principles and usages of the time being of the Muslim faith and for the instruction of children and adults, the promotion of such religion and other charitable purposes, time to time being directed by the committee hereafter referred to, such premises being known to the trust. So those are the charitable purposes.
Actually, the last part of Clause 2 might help you quite a lot.
Yeah. So I'm keen to clutch at any straws I can.
Well, I think the last part of Clause 2 really might help you on this point.
Yes. Yeah. So I hadn't focused on that, but yes, that's right. The charitable purposes are set out in Clause 1.
Yes.
And so it can't be said that if there's after acquired property, they're not held on those charitable purposes. Because those charitable purposes are set out in Clause 1, and my Lord is as usual right. Clause 2, any acquired land there's a specific reference back to Clause 1.
Yes.
My Lords, the point I was making, I think I've already made it in interchanges with the court, is that the judge was faced with a straight choice between London and Dewsbury, and the relevant terms of the two trusts are the same. And the point, and we say there's a false dichotomy. It's not money for the purchase of the land on one hand, or money for the Dewsbury Trust generally on the other. We say the choice was either money for the purchase of the land via the existing Dewsbury Trust, or money for the purchase of the land to a wholly new London Trust. And the point we made, and I think it's the point that's, yes, and the judge finds, if you look at what the judge found about the 1996 deed, he finds that, well, it goes back to the judgment. It's 151 of his judgment. He finds that Mr. C1 has lied about when it was signed, when it was brought into existence, but he finds it's likely to have been brought into existence sometime. I think it's in 1998. But at 151, it's, 151 in his judgment, which is at page, divider 10, page 188 of the core bundle. It's his fourth point. Fourthly, it does not mean the 1996 declaration trust was or is invalid or declared without proper authority of the settlers. That authority would have continued after acquisition until a valid formal declaration trust was declared. The question is whether it was within the terms of the authority. In my judgment, it was, as intended, the trust of Abbey Mills place Russian preaching and teaching in the Muslim faith. It's true, it did not specify control from London. Trustees were London trustees of London property. Those trustees that had power to appoint additional, as long as they were Sunnis. It's true, it did not specify use of the person to be, but I think adequately covered by the trustees' point. In any case, it was never used for HJ purposes. So he finds that it was, contrary to the evidence C1, manufactured after the date it was given, but nevertheless it was a Matheson trust, which means that the claimants are stuck with it. It's the terms of the trust under the implied authority, and no one of the claimants or some of the beneficiaries have sought to challenge that. So that's the point. They're stuck with it. And the point we say is this: if you look at paragraph 1, where the judge deals with the November meeting, it's paragraph 83, and I'll come to deal with this in a moment. He focuses on, it's a quote directly from C1's witness statement towards the bottom of the page. He said that, and it's 1, 2, 3, 4, 5, 6, 7, 8 lines up from the bottom. He said that in the November 1994 meeting, people were saying to organisers, quote, "Whenever now we give you money, please don't give anything to anybody except only for this land," unquote. And that's a direct quote from the first claimant's witness statement. The organised claimant offered reassurance was denied, but again, fair this was all evidence. He was not cross-examined about it. Now, we submit this, that doesn't justify the judge's conclusion that the money was donated under a wholly new trust. If it's right that those who loaned or donated the money were almost wholly from the London community, even if it's right that there was a reluctance to see any of the money go other than to Dewsbury, other than for the purchase of the land, even if it's right that people who loaned or donated the money wanted the money to go for the purchase of the land, and even if it's right that 2 out of the 3 of those people who were charged with collecting the money were not Dewsbury trustees, 1 D14 was. All of those do not justify the conclusion that those donors intended the money to go to a wholly new trust. Now, I accept, as I'll come to in a minute, that there were passages in the evidence of C1 and to a lesser extent Mr. Raman who specifically mention a new trust. But all the other witnesses, as I will seek to show you, because I want to show you the sea of evidence and not invite you to island, their evidence amounts to simply saying, well, we wanted the money to go to purchase this land. And if that's right, that is not sufficient to make a finding, or to found an evidential finding that what they intended was the money to go to a wholly new, as yet unconstituted trust, and that's what we say. And the judge clearly thought those words were important because he quoted them directly in his judgment. And that's the point we say that, and we echo Lady Justice Ford picked up when she gave permission to appeal, except that she's only giving permission, but it's a good one. The point that the judge focused on, we say don't justify his ultimate finding. And that's the second point. My lord, the third point is the full frontal attack on the judge's finding that the evidence given by C1 in particular as to what was said at the November meeting was, he accepted that evidence. We say it was not logical or rational to do so in all the circumstances. As I say, the points we make are cumulative. Because on the rationality argument, I rely also upon the 2 points that I've already made, in particular the presence of the receipts. Before I do that, can I just direct you to certain passages in the authorities? I'm no doubt you're very familiar with them, but just because there is a trend in authority, both first instance and appellate court, which is, I won't say dismissive of, but urges extreme caution on a judge when hearing and considering contested oral evidence. And that starts with the well-known Guestman case, and we have that in the bundle of authorities, which is
in a sense, sorry, Mr. Arnold, in a sense, the judge accepts all this.
Yes.
Because he said, he imposes a rule on himself that he won't accept the first claimant's evidence unless it's corroborated or is inherently plausible.
Yes.
So he's following these rules. Your case must be he broke his own rules.
I mean, there's no corroboration of C1's evidence, save for a brief passage from Mr. Raman, and the documentary evidence is dead against it. This is our Occam's razor. I'm afraid I had to go and look that up. But the point is this, that if C1 is right, if he's being honest about what happened at the November 1994 meeting, and we don't say a meeting like that didn't occur. Meetings might have. Our own evidence said there were meetings or a meeting. Absolutely inevitable there were meetings about in the London community about how they were going to organise this. But it's the detail of the meetings, and one meeting, and specifically the fact that there was going to be a new trust, and that he, C2 and D14 were going to be appointed as trustees of this new trust. It's that detail given in a number of paragraphs in his witness statement, and not resigned from in his oral evidence, which is incredible. The fact that he's giving that level of detail about a meeting, undocumented meeting, which took place 28 years before the date of the trial, which meeting had never been previously mentioned until his witness statement. It's quite an astonishing level of detail to remember. One can speculate one's difficulty remembering, certainly I do, was to happen last week, let alone what happened 28 years ago, and in that detail. So I accept the judge reminded himself. But there was no documentary evidence supporting the C1's assertion. In fact, all the documentary evidence was dead against it. And to say it was plausible is only plausible if you accept what C1 says otherwise. I mean, there's two things about plausibility. One, the test is not plausibility, it's credibility. I accept if something's plausible, it might be credible. But it's credibility. And it might be said that the C1's detailed recollection of what happened at that meeting, was too plausible. It was too accurate. It was too supportive of his case that he wanted to produce. But, as I say, it's the Occam's razor point. Either he's right about what occurred at the meeting in November 1994, but then you have to discount all the contemporaneous documentary evidence which goes against that.
When you say all the contemporary documentary evidence, you mean the receipts?
Well, the receipts and the subsequent evidence, there's evidence I'll take you to, the holding out post that, which are they're not bang on contemporary, but they're much nearer the time. And they go all the way up to 2011, writing a letter to Boris Johnson on behalf of the Dewsbury trustees. But you have to explain away all that. Or you say, well, actually, the documentary evidence, contemporaneous and near contemporaneous documents is right, and he's lying in the witness box. And that's the simpler explanation. We say that's the one the judge should have accepted.
But just help me on this, while we're just sort of looking at it more broadly. How do you explain the fact that legal total ended up with C1, C2 and D14?
Well, it's good. C1 was in charge, where he was liaising with the solicitor. There's no doubt that certainly C1 had a key role in organising the funding of this. And it's not in doubt that he instructed solicitors that he knew to organise the purchase of it. There's no doubt about that. And we'll come to what he said to those solicitors in a moment. But at that time, what happened, and you will see, is that just before
well, you're giving me interesting information, but with respect, I don't think it's an answer to my question. What on your client's case explains the legal owners of the land being C1, C2 and D14?
Because that's who C1 organised it to be.
And why?
So that must have been a flat-out breach of trust on your case.
Yes.
And when was any complaint made of that?
Well, it was. There's contemporaneous documents. I mean, I'll show you that.
So,
yes.
Just to be clear, implicit in that, I think, is that you accept that at some stage, Mr. Mohammed thought that this land should be held on separate trusts.
Yeah. Yes. He instructed the solicitors at some stage, belatedly, to say it's going to it's in the name of C1, C2 and D14, and the charity that it's going to be holding on behalf of that, and with the London in brackets. Yes, he did.
And do you have a case as to when he first formed that view, that the land should be held on separate trusts?
We can see the solicitor's correspondence when, I mean, what appears to have happened is that he was instructed towards just before exchange. There was an instruction from Dewsbury that the land was to be held in the name of certain 10 people, the Dewsbury trustees. And that was eventually, the C1 didn't like that, and that was eventually ignored, and the land was transferred into the name of C1, C2 and D14. There's then, subsequent to that, there's documents signed, as we'll see, by C1, C2, certainly, saying that they held the land on trust for Dewsbury, which C1 complains, oh, I was browbeaten into doing that. I had 2 lines to Hafiz Patel, who was the spiritual leader, which were then not actioned.
I forget. Is it apparent that by 1996, Mr. Mohammed was contemplating, I mean, in the documents, is it apparent in the documents that by 1996, Mr. Mohammed was contemplating trustees who weren't Dewsbury trustees?
Well, it's true the transfer was in
Well, that's 1998, is it? Well, I can't remember.
No, sorry. The contract is 96 and the transfer is 98. I think that's right, isn't it? Yeah.
And the contract is in the name of the three.
Yes.
So by 1996, one can infer reliably that Mr. Mohammed intended separate trusts.
Well, it certainly he contemplated the land being transferred into the name of those three. Whether he contemplated there to be a separate trust or not, there is an evolution. But at some stage, there's no doubt, Mr. Mohammed.
Well, he can't have thought that legal title was being held by Dewsbury Trust because 2 out of the 3 were not Dewsbury trustees. And I think you're accepting that was deliberate.
Well, yes, it was deliberate that it was transferred into the name of those 3, one of whom was a Dewsbury trustee, and the other 2 weren't. But then, let me take you, can I deal with that when I do that? Well, I mean, perhaps you don't need guess.
I don't want to stop you taking back to what you want to take us to.
Well, I don't want to
I think we're all familiar with guessing.
It makes it quite clear that you urge extreme caution in dealing with that. And yes, you look at contemporaneous documents, and we say there were documents here. And secondly, or near contemporaneous. And secondly, you look at plausibility. Now, the plausibility only arrives if you believe what else C1 says. Anyway, the judge did take those into account. He recited an account of them, but we say he didn't apply it. And it starts with the learned friend's closing submissions. Again, back to those. One looks at that's at supplementary bundle 3. Divider 162, page 711. And he says, they say the crucial event here is the meeting in November. That is the meeting at which the appeal for Daji was initiated, at which the fundraising process commenced. So that's where they pin their colours to the mat. But of course, that's in the context of what goes paragraph 1, back over to paragraph 1, 2, 3. Where he says, in this present case, of course, likely to need to rely substantially on the context of the is made, not least because there's no written document which the precise nature of the PLA funds calculated formula presented for them to read, such as their intention to rely as to construing them. Well, we say that's not right because there's the receipts that are evidence of that. Now, the only evidence of substance we say is C1, and let's look at C1's witness statement. And again, the point is we don't say, and that's the point of cross-examination, we don't say that a meeting didn't occur. We just say that the detail, that is a particular detail, that there was going to be trusts, a new trust arising with the 3 people who were appointed to fundraise as the trustees seemed incredible and shouldn't believe. If one looks at it's his witness statement, which is supplemental bundle 1, divider 2, pages 20 to 21. And it's 5.3, it starts, and he gives a very detailed account in paragraphs 5.3 down to 5.15. And the quote that the judge picks up is at paragraph 510. And then at 512, he says it's decided in the meeting that we need to go appoint proper trustees to be responsible for the project of Appellant community, appoint the whole London Shore. So that's the first mention of trustees, that they were to be trustees for collecting the money. (513), he says, again mentions 3 trustees, one should be called treasurer, 1 secretary, 1 chairman. And he refers then at 513, the last sentence, to the London trustees. And then 515, it's also decided in the meeting that the land should be bought in the name of the 3 trustees and that they will run the charity for the London community. That's what the London community understood in those days. Finer details of this would have been discussed here. So, detailed evidence. At this meeting, we appointed 3 trustees, and there was to be a new charity of which we were to be the trustees. Remarkable level of detail, recollection, for a meeting undocumented, which took place nearly 30 years before he was giving evidence.
Why is it so remarkable? I mean, this was a major event in the life of the community and in his life, because on his case, of course you say he's incredible, but on his case, this is how he came to be a trustee of this trust and to acquire legal title to this valuable piece of property. So why shouldn't he remember it in some detail?
Well, you could say that, but we still say it's remarkable. I mean, how much detail can one remember of remarkable events in one's life, particularly given the context here? And that's why I was going to take you to Guestman, the flashbulb moments, because memory is an evolving thing. And this is a witness who has every reason to put forward this evidence, particularly given that the schism which has arisen in the religious movement since then.
You see, this is why it becomes important to focus on the question I was putting to you earlier about what the alternative explanations are for the sequence of events. Because you see, on his account, we have a coherent explanation as to how it is that 2 years later, the property is acquired by those 3 individuals. And what is the alternate coherent explanation coming from your side as to why the property is acquired 2 years later by those 3 individuals? At the moment, I'm still struggling to find it.
Well, I think it's clear that the Dewsbury trustees, I'll come to that, came to take the view, right, well, thank you very much, you've raised this money, we're well done, you've done very well, now can we have it now in the name of the Dewsbury trustees? And C1 just refused. There's some evidence subsequently. I mean, this land is polluted. It has no planning permission to be used as a mosque. Still has no planning permission to be used as a mosque. It's a temporary planning permission for 2 years. But that's lapsed.
I suspect it's much too late to serve an enforcement notice.
I don't think it is.
Well,
there's all sorts of procedures. There's been an appeal in the High Court. Anyway, look, that's the point. So what happened was at some stage, Dewsbury said, well, we should really sell this because it's not going, we can't use it as a mosque. And there's all the evidence about it. We went up to meetings in India of the main council, and there was a disagreement as to whether the land should be sold because it was polluted and couldn't be used as a mosque, and it was decided that no, it shouldn't be. So there were disagreements about what the land could be used for, whether it should be actually retained for that. I mean, that was later, but it's clear. Dewsbury asked for it to be transferred to the Dewsbury trustees, and C1 refused.
But doesn't that, to an extent, corroborate his evidence? I mean, if he had always thought that this land was going to be held for Dewsbury, one might have thought he'd have handed it over. At any rate, by late 1996, he didn't.
Yes, but he then entered into, he signed several documents saying he did hold it in trust. And one might have thought if he was that keen, he would have handed out, he would have printed receipts which said New London Trust. That's right. Except that's the point. The judge said it was plausible, but only if you believe what C1 says. He does transfer it to himself, but either he's a full-time liar or he's not. He is a liar. But
he obviously wasn't lying in everything he said.
Well, what doesn't
So,
matter.
for example, you don't dispute that there was, in fact, a meeting?
Well, there might have been a meeting. Yes, there was meetings. I'll take you to the evidence of that. We can't give the detail. Our witnesses didn't give the detail of that because, quite frankly, it's not credible to do so. I say that's plausible, yes, because I entirely understand how does one organise fundraising on behalf of the London community. One has a meeting about it.
Yes, indeed.
I want to take you to part of his cross-examination.
Yes.
Which is at day 5, which is at supplemental bundle 4, divider 168. Page 901. And if you look at internal page 409, he's been cross-examined by Mr. Westwood. And this is it starts off about the 1996 trust deed. That's line 20 question. Because I'm going to suggest to you, Mr. Mohammed, is that you did not send this document to 4 sides at all, did you? I did, before completion.
I beg your pardon, I must be on the wrong page.
I'm
Can you
sorry,
give me
it's
the
my
reference
fault.
again?
It's supplemental bundle 4,
Yeah.
divider 168,
Yeah.
page 901.
I'm on the wrong page.
I'm sorry, it's my fault.
Have we jumped? Is it all on the same day? Yes, it is. Yep. Yep.
And it's internal page 429, which is top left-hand corner.
Yes.
And I'm sorry. And I was reading from line 20. And if you look up, you'll see it's to do, the initial question is to do with the trust deed.
Yes.
Question. Because what I'm going to suggest to you, Mr. Mohammed, is that you did not send this document to 4 sides at all, did you? I did, before completion. Just going back to your witness statement, paragraph 9.2, you say you called Mr. Isaacs in November 1994. Then in the middle of the paragraph you say, the details of how we would do this as a charitable trust were worked out later. I knew that other Tablighi centres in the country had their own written constitutions, and London Shore started by looking at those to work out how to set ourselves up as a separate organisation. When did the London Shore start to look at the written constitutions of other Tablighi centres? This is a November meeting, 94, when 60 members, local people, gathered here and were very clearly decided. They said that any money we give to you would not transfer to Dewsbury. We should have separate organisation. This is what we start looking at the draft final constitution. Your evidence is it was in November 94. It started. That the London Shore started to look at other constitution. Yes. Who in the London Shore were involved in that process? Yes. We have 25 people of London Shore, plus 60 of those responsible for others attended the meeting. I believe that was the time when it started, the trust. Who in the London Shore was involved in the process of looking at the constitution of other Tablighi centres? I cannot remember exact names, but everyone knows about it. Question. So all of the London Shore were active in the process of looking at other Tablighi centres, is that right? Yes. So he's questions about this, and he goes further. He says, no, not only did we use it, we started looking at the constitutions of other organisations at that meeting, or after that meeting, and we had the December 1996 deed as a completion. Well, that's a lie, quite frankly. So he's the whole meeting, he starts exaggerating about it, and it's a lie. And then it's interesting, actually, if you go on there, and to the top of page 132, well, sorry, just read the rest of the question. Which other Tablighi, and I'm starting the 14315 where I left, or which other Tablighi centre constitutions did you look at? Various, but I cannot remember which others. Also other mosque organisations looking at just to finalise our draft. What did you look at in the terms of documents? Just looking at how we can separate London Trust. So you look at the constitutions of those other Tablighi centres plus other mosques. Did you make any notes when you were looking at those? There was a team of us looking for that. Did you make any notes when you were looking at the constitutions? We read those and we tried to put things together. Did you make any notes in those constitutions? I can't remember any notes. Do you still have any notes? I do nothing. Do you have any of those other constitutions you say you looked at? Yes, we used the details, various clause things. Can you remember which ones you used? I can't remember. It's about 30 years. So we can remember details of the meeting, but he can't remember anything else. And of course, the judge finds that his evidence in relation to the 1996 deed is a lie. It's right that I take you to the evidence of Mr. Rahman. His witness statement is at Supplemental Bundle 1, Divider 1, and this is the last thing I will do before the short judge.
What tab number again?
We're going to, it's tab number 1 of Divider of Supplemental Bundle 1. Paragraph 6 to 9 is the relevant evidence. And you said we've already looked at the sentence, paragraph 8, all loans were given receipts. But he goes on, paragraph 9, I recall the elders of Lunch appointed 3 trustees per land. I would have objected to Abbey Mills being transferred to. So that's as high as the claimant's case got from that. I mean, if you look at paragraph 6, he was questioned about that, and he accepted that Hafiz Patel, whom was the spiritual leader of the entire movement in the United Kingdom, based in Dewsbury, and one of the Dewsbury trustees. If you read that paragraph, it looks as if Hafiz Patel was at that meeting. He accepted that he wasn't, and that he was conflating 2 meetings. But he was cross-examined about this. Again, Supplemental 4. It's 164 divided by 164 at 819. I'm going to, because of the time, I'm going to invite you just to read internal pages 94 to 100, if I might.
And then we will break.
I'm sorry to give you some work. Well,
Shall we just do that?
yes. My lords, I'm very grateful. I'm sorry to trespass into the show, Chairman. Thank you.
And I think,
But would you accept, since we've just looked at this, that paragraph 9 doesn't seem to be challenged? He's taken to paragraph 9, he's asked questions.
Well,
Can we get back to
yeah, of course, yeah. Yeah, no. Oh, have we got? Oh, sorry, that's. Yeah, that's.
Always doing that. I was told, unless you are crossing carriers, completely unforgiving.
Did I tell you about that? I was in the truck.
It's the area. It doesn't matter. He doesn't say paragraph 9 is false. That's not his style.
No, resume it now. No.
He's gentle.